Thank you, Laura, and welcome everybody. Good morning to our few hundred clients and managers that we have on the webinar this morning. I hope you like the title and it pulled you into this webinar this morning, because construction projects gone wild is something that Ken and I'm going to introduce him in a moment, have lived through for over 35 years in practice, specifically with community association matters. We have absolutely seen the good, the bad, and the ugly associated with these types of projects. And today we're going to deal with a variety of those projects and those issues that you typically confront. And hopefully after this webinar, you'll learn some things that'll help you avoid these problems in the future. So let's go to the next slide, please. So as Laura mentioned, I'm Steve Lesser. I run the practice group for construction at Becker. I've been there for approximately 37, 38 years. I've done everything from a new roof on a Century Village condominium to doing all the contract documents for the Brickell City Center project down in Miami, totaling $1 billion. And I've seen a few things over the years in litigating all construction cases, which also filters into how we handle transactional documents. The other perspective here is going to be given by Ken Direktor, and Ken should not be a stranger to any of you because he has run the practice group for community association law at our firm for a long time. And like myself, who's board certified in construction, Ken is board certified in condominium and plan development law through the Florida Bar. And he has a lot of experience handling a variety of associations, running from condominium associations, homeowners association, timeshare communities, and a lot of country club communities throughout the state of Florida. So the way that this is going to interplay between Ken and I is that with construction, our worlds often collide, because a lot of what we do in the construction context really depends often about an interpretation of your documents that form your community. Figuring out what is a limited common element, what is one unit owner own, what is the association loan own, and how they maintain these things. So that's where you're going to see the interplay between the association law context and the construction context. And together, we hope that we can give you some perspective on how to guide you through the construction process. Next slide, please. So if any of you remember anything about this webinar today, this is the one thing I want you to remember. Money will make you stupid. That's a critical point of this entire webinar, because we have found in the past that our clients will often make a distinction and attempt to retain either an engineer, an architect, a contractor, just on the basis of money. And that is a huge mistake, because the most important thing that you need to do is hire someone that's going to do your job and do it right, who's competent and will take the time and pay attention to detail. Because if you go the other way, they will automatically cut corners. Now, lots of times I'm asked, why do you even need a contract? Why can't we just shake hands? Well, maybe that works in Ohio or Illinois, where you're from, or where your board members are from, but it doesn't work so well down in Florida, because you don't really need a contract until something goes wrong. And then you'll be fortunate to be able to pull out that contract, and it will adequately set forth what your rights and responsibilities are and your remedies in the event that something goes wrong. Well, what can go wrong? Well, there are tons of things that can go wrong. A contractor today that's solvent could go out of business. A chunk of concrete can fall off the building and strike a car or a resident at your community. You may have liens being impressed on your property that may make it hard for you to have sales go through. You could have roof tiles that fly off in conditions that are not hurricane conditions. You could have a hurricane bearing down on your community. What do you do when that happens? If they have to board up and they have to make the area under construction safe, who pays for that? Who decides when the contractor will demobilize and get their equipment off the job to avoid it flying around and causing damage? What happens if you got to get rid of the guy? If you don't have a termination provision, how are you going to make that happen? What kind of notices do you have to give? So the fact of the matter is there's a lot of stuff that goes wrong, and that's really why you need to have a construction contract. And many times our association clients will say, well, I'll let the contractor come on the job and do some remedial work first before they get a permit. They've applied for the permit. Even though we don't have agreement, I'll let them come on board. Big mistake. I'll tell you why. The one thing I want you to remember, in addition to money will make you stupid, is the fact that in a negotiation context, when you're trying to protect yourself and your communities, the time when you have the most leverage in any construction project is at the outset, before you have a contract. Because you know why? They want your money, and you're holding all the cards, and you're holding their money, and you haven't signed on the dotted line yet. It's at this point that it's critical that you make sure that you're properly protected by your contract before you sign that contract. Because once you sign that contract and the contractor walks on site, they're in control. If they dig up some dirt, they can lien you if they don't get paid. And they're in control of the site, not you. And there's a building permit with their name on there. So they're controlling it. So right now is the best time in order to make sure that you are protected at the get-go of the project. Now, we're going to talk a lot about the terms and conditions of the contract, but the first thing I want to do is turn it over to Ken, because at the outset of any construction contract or any construction project, Ken is your association lawyer, and he's often the first one on the front line, and he tells you what you want to do, and he tells you how to proceed with respect to what you need to do based upon your formation documents and community association law. So Ken, at the outset of any construction project, what is your best advice to give to your clients? Next slide.
Well, I want to tag on to your comment about money will make you stupid. Construction projects, particularly complicated construction projects, are one of the areas where the board members are called upon to make business decisions in an area where, for the most part, they do not have expertise. So how do you compensate for that lack of expertise? This is where you hire a consultant. The board members have the protection of what's called the business judgment rule, which is a Florida common law concept that says that as long as you're making reasonable business decisions, a court is not going to substitute its judgment for that of the board. The question, of course, how do you make a reasonable business decision? Steve just said money will make you stupid. Stupid is never reasonable. If you make construction or maintenance and scope of project decisions based upon cost, you leave yourselves open to a challenge to the reasonableness of your decisions. If you make those decisions based upon the advice of a competent, licensed engineer or other consultant who has expertise in the area that you are considering undertaking a project, you are clearly acting reasonably, and your decisions will be protected by the law. So,
Ken, let me jump in there. What about the fact that the association is trying to save money? They say, hey, we have a unit owner who used to be a project manager up in New York on a big construction project. He can inspect for us. He can tell us what the scope is. What do you think about that?
Everybody's got the same unit owner living there. You hire a licensed, insured Florida engineer or consultant, not an armchair quarterback from another part of the country who says, I can save you a few bucks. It is always a recipe for disaster when you hire people or rely on people who don't have the skill set to do the project for you. Steve will talk later about hiring a plumber to do a roofing project. Or you might as well hire an allergist to do your heart surgery. It is not a reasonable business decision. Now, Steve alluded to who approves the project. You have to make the distinction between a project that is necessary maintenance and repair, which almost always falls within the purview of the board, as opposed to a project that constitutes an alteration or an upgrade, which in most communities will trigger a requirement for a membership vote. That is a discussion to have before you sign a contract, before you levy an assessment, before you put a shovel in the ground or a hammer to a nail. And you need to talk with your association attorney about this, because based upon recent changes to the statute applicable to condominiums, You cannot go back and get approval for an alteration after you've already done it if you started it without getting the requisite approval. There are limited circumstances where that law applies, but it could be catastrophic because it prevents you from later ratifying a decision that was not made in a procedurally correct manner. So, is something broken? Are you making the scope of the project consistent with an engineer's recommendations? Are you designing the project to replace what was there with like kind, or are you making changes? If you are making changes, are the changes because you want to modernize the look or improve the aesthetics, which will trigger an alteration vote in most cases? Or are you making changes because you don't want to replace a 1970s product with a product that doesn't reflect changes in technology or the availability of more durable and easier to maintain and better warranted products? These are questions and discussions to have with your counsel and your engineer up front. And it is important to get these things in writing from your engineer. I ask for these things in writing all the time. I want to know what's broken, what's the required scope of the repair, and if you want us to use something different from what is there, what are the engineering reasons for using a different product? The next concept that you need to deal with before you break ground, how are you going to pay for it? You have to line that up and deal with it ahead of time. You're going to get pushback. Steve alluded, we'll go back to the money will make you stupid. That doesn't just apply to the board. That applies to all the members who don't want to put another penny into the project, even though their windows are ready to fall out and their sliding glass doors no longer work and they're all caulked shut. You have to look at what needs to be done, and your owners have to be prepared to pay their share of it. Now, you can soften the blow to the owners by using reserves if you have them, by special assessing if you need to supplement the reserves, or if you simply don't have adequate funds on hand through operating funds or surplus. But a lot of communities also go to financing, and I'm going to spend a moment on financing, then I'm going to turn it back to Steve. Banks are perfectly happy to loan money to condominium associations, homeowner associations, and co-ops because you're not going anywhere. You're a safe borrower. You can levy assessments against your owners to repay the loan. But having financing allows you to draw down on a line of credit while the work is being done to make sure that you have the funds to cover the construction draws submitted by the contractor. Typically, that part of the financing is interest only. And then when the project is done, the loans convert to an amortizing loan, at which point you can give your owners the option to either pay their share in full or pay over time, but those that pay over time pay the interest. These are important discussions to have. Again, just like who approves the project, how you're going to pay for it is an important discussion to have with your association attorney before you get too far down the road.
Hey,
Laura,
Ken, on that point also, you should be mindful that whenever you have a lender involved, oftentimes that lender is going to need to approve the form of the contract. So you can negotiate all day long with the contractor and then have a contract that you actually sign. Then the lender looks at it and says, no way am I going to agree to these terms, or you need to have a bond. So what about that, Ken? Do you have anything to add with respect to that issue?
Well, I don't often see the lenders wanting to see the construction contract, but you are certain, and that would probably apply more to initial development or initial construction. But with repair projects, the lenders will want to be able to designate what the loan is for. So you will be limited as to what you can use the loan proceeds for. So remember, when you levy the assessment, where you have to levy an assessment, you have to specify all the purposes for which the funds will be used. When you borrow money, make sure you describe the intended purposes as broadly as possible. For example, when you do a construction project, you not only have to pay the contractor, you have consultants, you have professionals, you have permit fees, you may have insurance riders that you have to buy. So make sure that you describe the use of the funds as broadly as you can. Let's go to the next slide. So I want to talk about licensing, Steve, and I want your comments. Obviously, we advise our clients always, without exception, use a licensed contractor for a work that requires a license, whether it be a general contractor or, as I know you will address, specialty licenses. Can you discuss some of the different licenses and how to verify that a contractor is in fact properly licensed?
A great question. And I have to tell you that from a construction standpoint, licensing is ground zero for any construction project. And I'll tell you why. Because unlike other jurisdictions, Florida by far has the toughest and the most stringent licensing requirements of any state in the United States. You've seen the headlines in the Sun Sentinel and elsewhere about unlicensed contractors, especially in the aftermath of Hurricane Andrew many, many years ago, that in the event that you go to court against an unlicensed contractor, I will tell you that no one has any sympathy for them. But you know who I have less sympathy for? You, if you hire an unlicensed contractor, because it is unforgivable based upon the opportunities you have sitting on a computer in front of your screen to check whether somebody has a proper license. You can do it for free and it'll take you less than 5 minutes. How do you do that? myflorida.license.com is a website that has the information compiled by the Department of Business and Professional Regulation. And by typing in the prospective name of the contractor, you can find out immediately what kind of license they have, when the license expires, and also what their history is of complaints against their license. You can do that. I'm telling you, this is not a lawyer's job, or it's nothing magic. You can do that right away to vet these people right away, because I will tell you, if they don't have a license, don't hire them. Now, not every trade requires a license. You know, drywall, for example, except in some local jurisdictions, may not require a license. But if the drywall is going to involve moving an electrical outlet, that will require a license. You need an electrical contractor to do it. So one thing I'll get into in a few minutes is the scope of the work and whether or not it requires a license. But I have to tell you that check with the DPPR about licensing. It's very easily done. Now, there's a big misconception that a general contractor, well, they can do anything. Well, that's wrong. They can't do everything, because if there is a trade that requires a specialty license, then only those specialty contractors can do that work. Who are the specialty contractors typically? Roofing, pool, spa, solar, mechanical contracting. So a general contractor can contract with you to put on your new roof, but the general contractor can't put on the roof. He has to hire a specialty roofing licensed contractor to do that work. And in the event that work is not done by a specialty contractor, then that person essentially is operating without a license. And so, although a general contractor can try and contract for all this work, but if they're doing work that falls within a specialty license, then you should make sure that they're hiring a licensed subcontractor to do that work for them.
Steve,
It is illegal. Yeah, go ahead, Ken.
Interject a question. One of the questions that has come in while you were speaking is that there's an understanding that occasionally contractors use another contractor's license. How does that apply in this context?
Can't do it. You can't have someone borrow somebody else's license. Every licensed contractor has to have a qualifying agent, and that qualifying agent is licensed. It is illegal and inappropriate for that person to lend their license to somebody else so they can perform that work. The party that has the license has to be involved with the project. Otherwise, they are subjected to administrative fines and penalties by the state of Florida for doing that. A very good question. But this is very loose. You know, sometimes you get a contract in, Ken, that has the name of a company. The individual that you're dealing with, he may have individually a license, but his company has to be tied to that license. Otherwise, you will be contracting with a company that doesn't have a license, and it will be treated as an unlicensed contractor. I will tell you where I see some of the most crazy types of issues on licensing, and that deals with interior designers. I remember a number of years ago, Ken, one of your clients, a country club community up in Palm Beach Gardens, was doing a golf clubhouse renovation for millions and millions of dollars. And so I say to them, who is your interior designer? Oh, we got the very best guy from Augusta National Golf Course. He designed their clubhouse. So I look him up and he's not licensed. I tell them, I said, you can't use him. He's not licensed. And they were arguing with me tooth and nail. How could it possibly be that the guy that did Augusta can't do our clubhouse? It's very simple. In Florida, he's not licensed and you can't do it. So the fact of the matter is that you need a license if you're an interior designer. Interior designers are just like all other design professionals. If they don't get paid, they can lien your project. Interior designers can go and do work in your individual condominium unit, but they cannot do interior design work in commercial spaces, like in the lobby or for the pool or areas that are populated by unit owners in their common areas. So interior designers are really looked at the same way anybody else is. You've got to have a license or you can't do that work. And if they have a license in New York, I don't care. They're not licensed in Florida to do that kind of work. Design build. A design build contract is when you have one point of responsibility. The law says, okay, there's an exception here. If you're a contractor, you can do a design build contract. In other words, I'll build it and I'll design it for you. The contractor can go ahead and contract with the association to do that as long as they have a licensed design professional that is designated that'll do the design work. Likewise, an architect can enter into a contract with a community association to design and build your project, even though they're not a builder, as long as they have a licensed general contractor in the wings that is licensed to perform that work, then they can perform that work and enter into a contract with you. It is illegal for somebody that doesn't have a license to enter into a contract with you if they don't have the right license, except if they're a general contractor. Like I said, they can sub it out by using a specialty contractor. But otherwise, it is illegal for someone even to offer to perform services that are outside the scope of their contract. So Ken, once we have the threshold issue of licensing established, we find out, hey, these people are licensed. You know, what is the next stage? What are the next rules that we need to follow that come up in the contracting standpoint with respect to a bid package and evaluation of bids? Next slide, please.
Okay, competitive bids. Now, by statute, in a condominium for a project that's going to run more than 5% of the budget, you're required to get competitive bids. In an HOA, the requirement is 10% of the budget. I think you should get bids for any job you're doing. I think it's always good to get competitive bids. I think that is a good and reasonable exercise of business judgment. Now, part of the reason you hire a consultant is to develop a uniform set of specs. If you ask 5 different roofers to bid on your roof, but you don't have a uniform set of specs, you may be getting bids for different approaches to the replacement of your roof. Those are not competitive bids because those are not apples to apples bids. Those are apples to oranges bids. So you start with a uniform set of specifications so that all of your bidders are bidding on the same specs. Now, how do you evaluate the competitive bids? Steve already alluded to the fact that you do not have to accept the lowest bid. You accept the bid from the right contractor for your job based upon the warranty, based upon the references, based upon that contractor's experience. If you get 4 bids for a project and 3 bids come in at $800,000, $900,000, $750,000, and then one comes in at $350,000, I admonish you, I encourage you, I'm begging you, remember the mantra that sometimes if it looks too good to be true, it probably is. So competitive bids are an essential part of evaluating the project and choosing a contractor. Now, the most important person going forward will be your consultant or engineer, but the decision of who you hire, which has to be based upon a competitive bidding process and the best person for the job, not the cheapest person for the job, is the second most important decision. With that, let's go to the next slide and let's get into the next step in the chronology, Steve, which is the contract itself. And I want you to obviously go through the most important terms, which is obviously the scope of work, the payment terms, and the time to complete. But we also got a question in while we were talking that I'd like you to make sure you address, because one of the issues you're going to talk about, which is one of your bullet points, which is code compliance, is what triggers a requirement for a code upgrade. For example, if you take a certain amount of the roof off, Is there a point at which a new roof is required? If you take certain windows out that are not compliant with code, what triggers a requirement for you to do a code upgrade as opposed to simply reinstalling what was there before?
Well, thanks, Ken. Great question. And a rule of thumb, although it does vary a little bit, is that if you're doing more than 25% of the work, so if you're replacing more than 25% of your roof, then the whole roof needs to be replaced and has to be all brought up to code. That's obviously a question you really need to confer with your engineer or your architect right at the get-go to find out what are the code requirements. Likewise, if you're going to put a structure on the roof, you got to find out whether or not your roof can withstand that weight of the new structure. Because if you don't have those calculations done, the building code officer or the authority having jurisdiction may red tag your job and may require you to demolish things and start all over again. Ken, you want to raise something?
If you do certain work on your roof, you need to make sure that it won't vitiate your existing roof warranty.
Exactly, exactly. So these are all questions that come up. And like I said, we could dive into this and talk about this for a long time, but we're trying to give you a flavor of the typical kinds of issues that come up. Now, somebody had a question and they wanted me to repeat the fact that the licensing website is myfloridalicense.com, where you can check out the licensing of any contractor or design professional you're thinking about hiring. But now let's get back to the essential contract terms. As I told you before, do you really need a contract? Well, I guess if you got somebody that's really trustworthy and a handshake, they'll do your work. Otherwise, when things go wrong, you need a contract. And I want to go over some of the essential issues. I will tell you that frequently when a client of ours gets a contractor who submitted a contract, sometimes it's on an AIA form, which is the American Institute of Architects. The American Institute of Architects have generated form construction contracts since the 1930s. They're updated every 10 years or so, but the reason why you shouldn't use them, unless you have a real reason to do so, is because they are written by architects and design professionals and contractors, and not by owners of construction projects such as associations. Some of them, sometimes we get comments, well, they use these all the time, they're standard contracts. They're not standard because they don't comply with Florida law. Let me give you 2 reasons why you shouldn't use them. Number 1, think about this. Can you imagine signing a contract where a provision says that the contractor will only be responsible if they knowingly violate the building code? Think about it. How are you ever going to prove that they knowingly violated the building code? But that's what's in the AAA documents. Let's say you're embarking upon a very big roof project or concrete restoration project or waterproofing and painting project, where there is a propensity for something to happen and then water can get in the building and damage other property. Under the AAA documents, one standard form provision that's been in there since 1997 is a mutual waiver of consequential damages. If you sign that contract and that mutual waiver of consequential damages is there and water gets in the building and damages your carpeting and damages your drywall, or a contractor improperly punctures a pipe and it causes a huge water flood, guess what? All those damages that are caused to you, the property damage from that leak, are waived and are not covered under that contract. So you will be out of luck. So that's just a small example. I use the AIA documents on some very mega projects sometimes, but they're heavily modified to protect the owner. So disabuse yourself that these are standard form agreements, because I'll tell you, when everybody says there's a standard form agreement, I say, well, I have my own standard form agreement. Here it is, and it protects the owners. One thing that you have to be aware of right at the get-go is whether or not permits will be required for your project. And that really depends upon the scope. I mentioned the example of the drywall before. Maybe that scope of work, if you're doing interior renovations like drywall, painting, new carpeting, wallpaper, maybe that won't require a permit. But once you start moving electrical receptacles around, once you start altering vents that are into the units or the air conditioning system, all those certainly require a permit. And that raises the next issue. If there is a permit, who's paying for it? Is it within the scope of your contract in terms of what you're required to pay? Is it including the contractor's cost? I suggest in all my contracts that if the contractor is getting the permit and the association is reimbursing them, that they reimburse them at actual cost without markup for overhead or profit or any other administrative expense. One critical issue with respect to any contract is the time to complete. How long is it going to take? I like to set forth how long it's going to take in consecutive calendar days with the phrase time is of the essence, because in the event you don't have time is of the essence there, then the time to complete is not a material term of the contract. So if they say we'll be done in 30 days and it takes 35 days, they material breach the contract and you can enforce that. One reason why you want the time to complete is you want to be able to tell the unit owners how long this project is going to take. You have to hold contractors accountable. And when Ken was discussing competitive bidding and comparing apples to apples, one critical point is how long will it take? Because you want to get the contractor in and you want to get him out and you want to pay him for his time and what it takes. If he's in there for an extended period of time, that could be a disaster for the association. Of course, remember that like in concrete restoration, it's not an exact science. This raised the issue that Ken raised about the importance of the proper engineer or architect. Usually those people are the ones that scope out the project. They know what the quantities are going to be. If the survey is wrong and they assess the extent of damages and it's too low, then the time to complete is going to be raised and going to be extended. So you want a fair assessment of what it's going to take based upon the scope of the work. Associations typically don't have damages in the event the project comes in late. So the law says that if you don't know what your damages are, you can stipulate a certain liquidated damage on a daily rate to compensate you for the delay. So if the project takes more than a day to complete, or 2 or 3 or 4 days over the period of time that is specified, then you would be entitled to get liquidated damages. They are to be assessed at the fair and reasonable cost it will take. So if you have an engineer that's going to be on site for 3 additional days, or security, those all filter into the liquidated damages. It provides a contractor a monetary incentive to get the work done on time. Retainage is also very important. Retainage is that amount that you withheld from the contract sum. Usually it's 10%, and that amount is withheld for the period of time in which the contract is being performed. And then once the contract is done and final payment is due, and they give you all the warranties, all the documents, the permits are closed out, you have unconditional waivers and release of lien from everybody. And if you have an elevator modernization program, for example, they give you the operating manuals and everything else. Once all those provisions are satisfied, then the retainage will be released to them. So it's a holdback to secure that they're going to do what they're going to say they're going to do in the contract. There's also SC and final completion. Yes, Ken.
But I know you've got it on the list for later, but can you tie in for the people listening the connection between the payment terms and the retainage and the need for a payment or a performance bond? Because I have always believed the two were related. Not that we would advise a client not to get a bond, but I believe you can mitigate the need for a bond if you set the payment terms and the retainage at a certain level. Is that a fair assumption?
Yes, it is. In fact, first of all, you should know that not all contractors can get a payment and performance bond, because payment and performance bonds are written by surety companies who are basically insurance companies who look at the performance history of the contract and decide whether or not they're a good risk. Because if something goes awry and the payment performance bond is activated, then the surety company could be at risk. For example, if the contractor completes 50% of the job and then leaves, then the surety has to come in and complete the job for the contract sum. And that's a risk that they're going to undertake. Likewise, if the contractor doesn't pay its subcontractors, then these lienors can place liens on the project. If you have a payment bond, the liens get transferred to the bond, but somebody has to pay the surety company back for that. So if you're not going to get a payment and performance bond, you may want to increase the amount of your retainage to make sure that in the unlikely event that the contractor leaves the job or they don't fulfill one of their obligations, that you have some pot of money available to you that you can use to remedy the problems in performance that you've experienced with the contractor. You also have substantial completion and final completion. Substantial completion under the job is usually when all work is done except for punch list work. So you have a substantial completion date. Once that's satisfied, they have to complete all the punch lists within 15 or 30 days. And then they have to satisfy the final payment terms, which means giving you all the warranties, closing out the permits, etc. Warranties are another big part of the puzzle here. I will tell you that just yesterday, I got a warranty for a large painting job down in Aventura, issued by Sherwin-Williams. And sure enough, the warranty says that this warranty will be interpreted according to the laws of the state of Ohio. Well, the project's in Florida. That is an unacceptable warranty. It has to be changed. What you need to do is at the outset of dealing with the contractor, tell him, look, I would like to see the form of the warranty that you will give us at the end of the job. And I usually take those warranties, I attach them to the contract to know that at the end of the job, this is the form of the warranty that I'm going to get. If you've got a roof that's ponding water and the roofer is going to do a new roof, and then he gives you a warranty that says this warranty excludes ponding water, well, then where are you in the process? Oftentimes I see roofing warranties that say that this warranty will only apply to a situation where the roof is actually leaking. So you can have water saturating your ceiling, but it hasn't caved down, the water's not coming into your unit yet. The warranty may not apply. So you really need to have a careful view of these warranties. Lien protections, we looked at this a little bit with respect to the payment and performance bonds. Be mindful that design professionals, interior designers, engineers, and contractors and subcontractors can put a lien on your property if they're not paid. At the outset of every project, you should be having a notice of commencement recorded. Once that's recorded, then everybody in the world is on public notice that they are doing work on your project. So if this contractor hires a subcontractor who you don't even have any contact with, they have to give you a notice to owner. And when you get that notice to owner, you know that you should request a lien waiver from them whenever you pay the contractor. If you stay in front of that and you administer the contract properly, then with each application for payment, you will see a lien release from all the subcontractors and suppliers so that when you pay the contractor, you will know that your property is free and clear of any liens. Insurance is a very important issue. We've had a lot of questions come up about insurance. The type of insurance that the contractor typically has is commercial general liability project insurance, which is CGL, where you should be named as an additional insured so that in the event there is a problem, and let's say that chunk of concrete comes off the building and strikes a car or a resident or someone else, you can make a direct claim against the insurance company because you're an additional insured. Likewise, you should have automobile liability insurance. Lots of times people say, well, why do I need that? Well, if the contractor goes ahead and he has a subcontractor on the job, or he tells one of his employees, hey, run to Home Depot and pick this part up that I need for this job, and he gets in a car accident, you want to make sure that there's insurance that'll cover that and so that you don't get sued. Likewise, one of the most misunderstood areas deals with workers' compensation. Lots of times a contractor will say to the association, hey, we're exempt from workers' compensation when we don't need it. Just because you're exempt, all that means is that the state isn't requiring them to get it. But if a worker is injured on your job, then the association could have liability for it. So you need to check with your insurance broker to say, if a worker that doesn't have workers' compensation is injured while doing work on the job, does the association have insurance to protect me? Or at the very least, I would suggest you get an indemnification, hold harmless from the contractor, that in the event that someone is injured on the job and they don't have workers' comp, that you are going to be held harmless and you're not going to be responsible. That comes down to getting a certificate of insurance. Lots of people rely on these things. If you look at the certificate of insurance form directly, it says don't rely upon it. What you need to see are written endorsements or the actual policy to make sure that the insurance that they say they're going to give you is what you have. You should also have a provision in there for hurricane protection. Lots of times we're out of hurricane season and they say, well, we don't need hurricane protection plan because we're not in hurricane season. Well, guess what? That contract that was supposed to take 3 months could extend out to a year, and then you're in hurricane season. What is a hurricane protection plan? It's a plan by the contractor that sets forth what is going to be required in the event of a hurricane, What's the game plan? If there's a hurricane watch, hurricane warning, are we going to move our equipment? Are we going to secure the site? If we have to board up and we have to cover openings, who's going to pay for that? When are we going to get paid for it? So a hurricane protection plan is important. Most good contractors have that. Indemnification, in the event that you get sued, the association, because of an act by a contractor who's working for you, you want to make sure that you're indemnified by that by that contractor for the damages incurred by the third party. So if the concrete chunk comes off and damages somebody's car, and that person that owns the car sues the association, you want to make sure the contractor agrees to indemnify, hold you harmless, and defend you for that loss. Termination, you want to get rid of the guy. How do you do it? There should be a specified period in there that you get 10 days after a notice of termination to cure. If you don't cure in 10 days, then you're terminated. And if you're terminated, you don't get any compensation. You get paid for maybe what you did, or there's a set off for non-performance. And then you get to Chapter 558, which is a construction defect statute and notice to right to cure. Lots of times my association clients will say, Steve, why do you waive that? Why don't you want 558? I thought it's supposed to protect us. It doesn't protect you. It's a convoluted process that could take more than 120 days to get a simple problem resolved. That's why I waive it. I would suggest that you have questions on that or you want to learn more about it. I've had several published articles by the Florida Bar Journal on the issue, and they're on our website. That basically sets forth, most of the problems with respect to the contract issues. Can we go to the next slide, please? So Ken, what are the other cost issues that can arise in a construction project, and how do we address those with our clients?
Well, for example, concrete restoration is a project that many of you listening have dealt with, and it's not a pleasant project, and it's difficult to plan for because it's a unit priced project as opposed to a flat cost project. And more often than not, with an older building, particularly where you haven't done concrete restoration, you're going to find what I refer to in this slide as latent issues, which means that when you open up and excavate the spalling concrete, you find problems beyond what were anticipated, because you've all seen the engineers do the surveys to decide the scope of the concrete project. They tap a hammer and they drag a chain. You think for a second you're back in the 19th century, but that's typically what they still do today. And that means that you're not going to know the full scope of the project or how far you're going to have to go until you expose the underlying reinforcement bars. There are some projects, for example, if you have to tent the building for termites, what about the owners? They can't stay there. I realize some of you may like to have some of your owners stay there, but let's face it, you can't. Do you have to pay for their relocation expense? That has to be discussed with your counsel. We've already talked about the fact that there are going to be delays that are going to, in some cases, create expense. You need to anticipate those. So when you plan cost, you need to address these issues, including cost overruns and potential damage caused by the contractor, because if the contractor does damage, it's not always the case that the contractor or his insurance company is going to just stroke you a check. You need to be able to deal with the damage and chase the money if need be, rather than simply waiting for the money to come in, depending upon the nature of the damage.
And Ken, on that point, how about documenting those damages that occur? Do you use your consultant to do that, to make sure that if there is insurance to chase after, that you've got the backup?
You always rely on your consultant. There were a number of questions raised about project managers or about unit owners or the board being involved in the project. Your eyes and ears on the project, that's your consultant. If you start to have your construction committee or a gadfly owner interfering with the project, you're going to have delays, you're going to have problems, and you may find yourself in breach of the contract because you allow someone to interfere with the project.
And Ken, doesn't that get back to this concept that is critical to association law? And that is the concept of the business judgment rule and who you rely upon. Can you just briefly talk about that?
It does bear repeating. Thank you. Boards are protected by what is called the business judgment rule. That means if you make reasonable decisions when you're exercising business judgment, including when you're deciding on the scope or the execution of a project, the boards are protected from liability. And I'll say it again, the courts will not substitute their judgment for how to do concrete restoration on your property for your judgment, as long as you are acting reasonably. You will never have 100% approval or buy-in or support from your owners. There will always be some who say this project is unnecessary. It's a conspiracy between the contractors and the engineers and the lawyers. This work didn't need to be done, or you're not coming into my unit under any circumstances. You rely on your engineer to determine the scope of the project, to determine how quickly the project proceeds, when payment draws are approved for payment. Always the engineer is your eyes and ears. And I don't want to leave this topic without addressing incidental damage. Incidental damage is not consequential damage. Incidental damage is damage that is done by a project which is unavoidable to properly complete it. For example, if an association has a vertical riser that has to be repaired and I've got to go through Steve's unit to access that vertical riser, incidental damage is the damage done to Steve's unit in order for me to access that vertical riser. That means the wall treatment, any other furnishings that I have to remove or destroy to get to that wall, to get to that plumbing line. The most obvious example for many of you is in concrete restoration. You've heard of the concept of unit invasions. That means the sliding glass door has to come out, the track has to come up, and some of the living room or adjacent room flooring frequently has to come out. Incidental damage is damage that is done that is unavoidable to complete the project. So all of the damage that I just described is incidental damage. A lot of your old documents, and if you're sitting out there with documents that were written in the 80s or the 70s, more often than not, they have a blanket incidental damage clause, which means that you have to pay for all the restoration of the unit interior. Now, to some of you, that may seem fair, because if the association's contractor has to damage it, shouldn't the association have to pay for it? But you need to be mindful of the distinction between an owner who has imported marble on their floor and an owner who has shag carpeting, where 10 square feet of damage can have vastly different economic consequences. Furthermore, if you have an unlimited incidental damage clause, it is almost impossible to budget for the job, which is why a lot of communities, when they update their governing documents, they don't eliminate the incidental damage provision, but they put a per incident cap on it so that they can plan for it and budget for it when they prepare for the job. Let's go to the next slide.
You know, Ken, one critical issue really is COVID-19. Can't stress this enough. I mean, it has plagued everybody and has put community associations in really a tizzy over what they need to do and how they maneuver through all this. You know, in the past, in all of our contracts, we've always had force majeure provisions, which means that if there's a delay, for example, or an event that is beyond the reasonable control of the contractor, such as a hurricane or bad weather, then the time to complete will be extended. And then there may be some compensation involved with that. And way back when, I will tell you that before March, you never saw a force majeure clause that really had COVID-19 or even thought about a bacteria spread or a pandemic.
It was
COVID-19.
It was the essence of a boilerplate provision, right?
Exactly. And that goes for, standard form documents such as the AIA, et cetera. So you and I have done a number of webinars on COVID-19, but I think that I would like you to discuss a little bit based upon your experience about what are the issues that you've seen, how you've addressed them, and the concept of having a specific COVID-19 protocol attached to the contract to govern the rights of those folks that are doing the work.
Well, the first question under the COVID-19 concern is whether or not the circumstances based upon the virus itself and the pandemic as it stands, which, as we all know, is getting worse again. Is the project something that needs to be done right now? One of the first things that I am seeing is frequent complaints from owners for projects that they consider to be non-essential that require contractors to be inside and throughout the building, like a lobby renovation or a hallway renovation. Do we need to do that now? And if the answer is maybe not, we have an elderly population, we have a lot of people living here who have underlying health conditions, we don't have a service elevator, we have narrow hallways, We don't have the staff to monitor the contractors, to make sure they're all checked in, temperatures are taken, masks are worn, that they don't use public restrooms. These are all things that need to be addressed before you decide if you're even in a position to do the project. If you're going to do the project, it has to be clear, and this also applies to work in individual units, that they've got to comply with your COVID protocols. They've got to check in through a uniform point. If there's a service elevator, that is the only means of ingress and egress. They've got to wear masks anytime they're outside the unit on the common elements. You have to control and regulate access. Now, back to the first point. Are you even going to do the project? Ever since the COVID crisis started to ratchet up back in March, communities have allowed necessary or emergency repairs. If your air conditioner goes out in your unit, if your stove or your oven goes out, of course you need to let somebody in so that those are functioning components. On your building, if the roof is leaking, you need to replace the roof, COVID notwithstanding. So you need to separate necessary projects from unnecessary projects. But if you are trying to keep your owners from engaging in what we will call discretionary unit renovations, it is much more difficult to justify that restriction if the association is engaging in discretionary renovations. In other words, non-essential work. So
Ken, aside on the contracting issue, aside from that, okay, what have you seen in terms of specific protocols that maybe the people on this webinar may learn about, maybe a model to follow in these types of projects?
The first decision is, what type of work are you going to permit? Are you going to permit non-essential renovation work as opposed to emergency repair? In either event, you're going to require contractors to have a limited point of access, and you're going to have to do deep cleaning wherever they have access. You're going to require them, as the slide shows, to have waste removal every day, not to do work out in the hallways, not to even be in the common elements. In most communities, the contractors are not permitted to be on the common elements except to go to and from their vehicles. And in some situations, once they come in the morning, they can't go to and from the unit a number of times during the day. They have to work in the unit until it's time for them to leave. So we limit the number of people who have access, and then we limit the method of access. Some are requiring all personnel on a project to stop at the front desk to have their temperature taken. Some even requiring them to fill out a questionnaire. In some cases, they are requiring them to show positive COVID tests. I had people working in my house, and during the middle of the project, the general contractor had all of them go get tested to make sure that nobody working in my house had tested positive. These are the issues. Who do you allow in? And to the extent you allow people in, how do you regulate their behavior in terms of coming onto and off the property, and what can and can't they do, and where can and can't they go while they are on the property? And you need to have the last point there, Steve, enforcement.
Yeah.
Contractors are not owners. They don't have a statutory right to be on your property. And while there is a legal process to file lawsuits and get injunctions and force people off property, if I have a contractor working in my unit, or if you're the association and there's a contractor working in an owner's unit and the contractor flaunts your association protocols for COVID, doesn't wear a mask on the common elements, leaves their trash there during the day, uses the common element facilities, which they're not allowed to do, comes in through points of access other than those that are permitted, you have to be prepared to say to the owner, if your contractor does these things, he's off the job. And you can have a 1 strike, 2 strike, 3 strike process. On the first strike, the job is shut down for a day or two. On the second strike, it's shut down for a week or more. And on the third strike, you say to the contractor, you're not coming back to our building. And if we have to file a lawsuit to keep you off the building, we're going to. Because when it comes to COVID, and this is how I have counseled all my clients for 8 months now, it is a constant balancing between life safety and operations and freedom of use. But if you have to choose which of those is the weightier concern, it is life safety. You always have to err on the side of protecting life safety while we have a pandemic going on. Steve, is there anything you want to add to the COVID discussion?
Yeah, let's get back to the cost issue. Let's say that before pre-COVID, you're engaged in a project, and maybe it's roof, and your contract allowed people to pass through or take elevators or gain access through stairwells in the building. And now COVID hits, and now you tell them you can't go through the building. You've got to arrange for access by scaffolding or by a lift or whatever. Who pays that cost? I mean, that's another consideration, that you can have all these great protocols, but you can't necessarily get the job done for the same cost that you anticipated, because now the contractor has to alter his means and methods in order to do the same work, and that may cause a problem. I will tell you that some of the things.
Before you leave that, let me answer your question with a question, because since March, you've seen new contracts and you've had to address this potentiality of a change in access being required. So the question is, when you've negotiated the point with contractors, it would seem reasonable to me for the contractor to say, if you've got to change my means and methods and it increases my cost, I need to be able to pass that on to the customer.
Right. It's really a negotiation tool, which I see happen. And most of the time, the contractors really want to continue to work. And in many respects, the associations want them to. And it's understandable if it's going to take more money. But what happens if you're at you're at a fork in the road where the contractor's not moving, the association doesn't want to give you any more money, you've got a contract that can't proceed forward? What do you do then? You can't terminate for cause, because there's really no cause to terminate. Lots of times in our contracts, we have a termination for convenience that says that the association can terminate for convenience, pay the contractor what they owe him for work completed, and they're gone. And many times, it hasn't been very frequently, but in post-COVID-19, we've used that termination for convenience clause to break the logjam and say, you're off the job. Maybe when COVID gets better, we'll have you re-engage and come back on. But for now, you're done. And that sometimes ends the discussion.
It bears mentioning with COVID that there is no one size fits all in terms of COVID rules or COVID protocols. I, of course, mentioned whether or not you're going to allow contractors on the property for non-essential or non-emergency work. And then, of course, I discussed, if you're going to allow it, what are the restrictions in terms of face coverings, points of access, taking their temperature, requiring questionnaires, and, of course, the enforcement mechanisms. But you have to take a look at your community and the surrounding region to configure your COVID rules. For example, in a homeowners association of detached single-family homes, there are very different concerns than the ones that Steve just alluded to, where you have contractors coming through the building and using the shared amenities like the elevator and the hallways. But nevertheless, you need to adopt guidelines that are consistent with the physical layout of your community, the demographic of your community, the presence of people who are more at risk than others. And you need to have a set of guidelines that is designed to maximize free use while preserving the appropriate protections for your owners. And this is an area where it is a constantly moving target, where boards have to meet every couple of weeks to revisit their rules and fine tune them to the changes in circumstances. Go ahead, Stevie.
Yeah, we basically run out of time. I want to personally thank everybody for joining us. Ken, any closing remarks you may have?
Well, thank you, Steve, and thank you everybody for attending. We could spend 3 hours on this subject, but obviously we're not. Use a consultant, make decisions based upon doing the project right the first time. You can certainly say we're going to save money on a consultant. We're going to save money by not paying a lawyer to do a contract. I would remind all of you of the old Fram oil filter commercial from the 70s with the mechanic leaning on a hood of a car, holding up a Fram oil filter, saying, you can pay me now or you can pay me later. The point in the project where you have the best opportunity to protect yourself is at the beginning. Use that opportunity to get a good consultant, get a uniform set of specs, get good bids, and get a good contract. Thank you all for attending. We greatly appreciate it. We have looked at your questions, and we hope we'll see you again in the future.